Hello, Toolboxers. Welcome to episode number 328 of the Immigration Lawyers Toolbox. It's an interview with Kevin Gregg. It's a backlog interview. As you see, where we have a lot of videos and recordings that we did, interviews that are backed up. We're getting them out now, but the info is primarily evergreen and it's just so good that we can't let it go. It's from December 2023 with, again, obviously Kevin A. Gregg, a great colleague who comes regularly, host of the Immigration Review podcast, must listen to, especially if you do federal litigation, crimmigration kind of stuff. Comes in really handy. He gives the cream of the crop in our podcast, especially the ones that I'm going to be more familiar with. There's more on the USCIS side of operations, affirmative cases. But it's a lot of fun listen to. It's not intended for individual legal guidance. Please consult with the attorney. You know the drill. Having said that, I do have a backlog of a lot of content too. We have old CLEs that are going to come that haven't really publicized. They're going to be part of the community. If you want to join that, get our newsletter, circle.so community. Email me at info@immigrationlawyerstoolbox.com and I'll get you in on that. Send me your BARD card and stuff too, because it's only for immigration lawyers. So I don't want like random people to come in. Also, importantly, we have a marriage green card course. That's the best thing you'll find. You learn how to do the marriage immigration process with reviewing case for inadmissibility, how consular processing works, affidavits of support, all that kind of stuff. I analyzing the statute, which is most important. Even if you don't buy the course, read the statutes and regulations, learn it from that. That's a hardcore way of doing it. INA 245, 8 CFR, blah, blah, blah for the affidavit support, for everything for the I-130. Learn that stuff well. INA 212, inadmissibility statute. We don't really do waivers that much, but like you got to know the statute to catch the issues. And we go over it in depth, 10 plus hours. I think it's 12 hours even. And then, just broken down into different parts. But the special thing we're doing is if you reach us out now, because I haven't edited the O1 seminar, which is training on how to do an O1 with the top immigration lawyers in the country that get together in Los Angeles. It was a live seminar. I haven't edited the recording, so it's a raw thing, but it's still like it's awesome. It's inside kind of stuff you're gonna love. We're doing a 2-1 package if we get enough people requesting it. So email me at info@immigrationlawyerstoolbox.com. If you're expanding your practice, if you're going into this area, if you want to have training materials for your team, you don't feel like making yourself. This is what you need. And we also have follow-up groups that come with this monthly office hours. You ask me questions. And most importantly, with all this stuff is developing relationships with me and other lawyers. That's the key to success I've found. And that's where the inside information comes. I was just talking with the last interview I did with Flavia Lloyd Santos. After the interview, I got some like game-changing information and I made some really bad business decisions on how I'm organizing my firm. And just by talking with her, I gained a lot. And these are what these private communications are about. I'm like, oh, that's the error I did there. That's the error I did there. I see it now. I kind of wish I talked to her sooner, but better late than never, especially in this case. So email me info at Immigration Lawyers Toolbox about that. And having said that, let's get the show started. Hey, Kevin, thank you so much for coming on again. I know you're jet setter going across the world all the time, at least America. But thanks for making the time. I know it could be a lot of work.
It's my pleasure. It's the problem is actually the fact that I have a habeas reply due tomorrow, and I've had computer issues. But this actual travel was personal to hang with friends and family in Florida. It just so happens that my family lives in Florida, so that's the price of living in California.
How are you going to file the case? Is it on mail or in person? Someone takes it for you?
No, it's federal court, so it's all been electronic for
Oh,
for.
okay. Okay, so I hate deadlines, so I try to do all the cases, but that don't have deadlines.
That's right. This was an interesting case. I mean, federal court, federal judges are going to do federal judge things. I actually had to call the court's chambers because the judge, there's a habeas petition, alleged unlawful detention for a non-citizen who's been in ICE jail for a year. And, the judge ordered the government to file essentially a response. And then in that order, the judge said, if the government shows good cause, so the government has the burden, then I have to reply. And so the government files a response. I'm like, is that good cause? Like, I don't know. Do I have to reply? When
Yeah.
when is my 7 days? I counted, and the court was like, yes, you have 7 days. I'm like, all right, let's do it over the holidays. Let's rock and roll.
Well, good stuff, man. Hardcore about this. We got a bunch of federal court cases that could be big. I think they're gonna learn, but we're probably gonna talk about next session or a couple of sessions from now when they make a decision. I think maybe Chevron deference is under attack, so
Oh
that
my goodness. Are we gonna do that on the podcast, on your show? A whole
the
Chevron
problem with
death?
these federal court cases, they're like 100 pages long, so it's so much more reading than a federal court case at a lower court case. But yeah, when they come, we'll do a session probably when we get the answers to these
No.
questions.
I'll have to do the Chevron deference one on the podcast. Ira keeps every time Ira gets a mic, he says, forget about the Chevron deference case with the fish. he thinks the SEC case is much more problematic. The Fifth Circuit essentially said, I want to say because of how the SEC judges are appointed, or maybe how it's funded, but I feel like it's because of how they're appointed, that the entire SEC judicial system is
Well, that's a big deal.
unconstitutional, which
Every the
is
whole
just,
thing.
it's the same as every admin agency, including immigration court. So, like, if the Supreme Court agrees with the Fifth Circuit, I mean, that's like every, like, that's the tearing down this entire case by case adjudication. I mean, it's wild. It's a wild term for admin law. And then in the pure immigration context, there's Patel Part 2 about whether facts and law mixed questions are
Yeah.
reviewable with all that. And then
Also non-reviewability. Yeah.
what's the other? Oh, they just took up the Munoz case, which is consular, right? The consular non-reviewability. I feel like there's one more, and it escapes me at the moment. But
I mean, they're going
yeah,
to look at thing again, NTAs and stuff again too. But
NTA is, of course, the Campos decision. In absentia motion to reopen NTA. I would have preferred that they not, because I'm loving the case law in most of the circuits, but it was inevitable.
yeah. Okay, so
But
that's what
here's something that's not inevitable, though. The first case that I have to talk to you about.
what's that about?
It was inevitable first. It's Argueta Hernandez v. Garland out of the Fifth Circuit. It was inevitable that this would go to the Supreme Court, I thought, maybe next term, but now not so much, because Argueta Hernandez, the very same Fifth Circuit panel, has reheard, it granted a petition for panel rehearing, and it has completely reversed its prior Argueta Hernandez decision from early in 2023. This came out in December, the second decision, and just complete 180 reversal. And I'm going to get to it in a sec. And it appears that oil has changed course and is now on the Respondents' Council's side on this legal issue. And so there aren't two parties arguing, which means after Argueta Hernandez has reversed itself, that means that multiple circuit courts are in agreement. The only circuit court out of agreement is the Second Circuit. And I've heard that they might be changing it too. So maybe this case doesn't make it to the Supreme Court if all of the circuits are in agreement. And the issue is this, I'm not sure if I've talked about it on your show before, but it's wonky as heck, but it's so consequential. When a non-citizen is ordered deported and then is deported and then comes back to the United States unlawfully, that removal order is subject to reinstatement, right? And if ICE reinstates the removal order, the only thing they're eligible for is withholding of removal and Convention Against Torture Protection. But before they can even get that, they have to go to a reasonable fear interview before an asylum officer. And if they don't pass that interview, you can appeal that no pass to an immigration judge. It's a whole thing. And then up to the circuit is what case law has said. But in these decisions, the Bakhtabai Patel Second Circuit decision and Argueta Hernandez, before the reversal, the Fifth and the Second Circuit had said, you only have 30 days to challenge a BIA removal order. That's always the law. And they were saying that with reinstatement, the 30 days starts ticking on that first removal order that's being reinstated, not the denial of withholding of removal that's always being challenged. In these cases, that first removal order has always been issued, years in the past, right? And then they come back in and you have to do this whole withholding only proceeding. So if you're tethering reviewability before the circuit to 30 days post-removal order in reinstatement, or reasonable fear, then none of it can ever be challenged at the circuits. It's wild. It's a wild thing for Judge Menashe on the Second Circuit to just, kind of say, without Supreme Court precedent on point, without it being in the statute and all that stuff. This is all based on Supreme Court's rationales in Guzman, Chavez, and Nasrallah a few terms ago, and Judge Menashe took it to another place, as did the Fifth Circuit in Argueta Hernandez, but the Fifth has reversed itself in December. You follow? It's pretty wild, and it's a huge issue with implications in bond as well. I mean, this is an octopus of an issue that I talked about on an AILA National panel. I was just hosting it with two experts on it. But I mean, it's just a crazy issue that the Supreme Court opened with Nasrallah and Guzman Chavez dicta analysis, whatever you're going to
Yeah.
call it, when withholding of removal and cat protection is not part of the final order of removal. There's a final order, and then you withhold that final order. You withhold execution. So if that's the case, what other results follow? That's another way of saying this very complicated issue. Anyway, the Fifth Circuit reversed itself, doesn't in a very non-citizen friendly way. And reading the tea leaves, it looks like oil was urging it as well. So we have a friendly DOJ on this jurisdictional issue. So there's that. And that's cool. And that would be one thing that would be worth talking about on your show in and of itself. But then the Fifth Circuit issued a bunch of non-citizen friendly stuff on nexus for asylum, on the fact that threats alone can constitute past persecution. Repeated credible death threats can be past persecution. The fact that even if there is a non-protected ground motive, like here, if MS-13 is trying to, extort, get money, otherwise harm this family, if they're also doing it because of a protected ground, in part, like the fact that the guy was very religious, very Christian, that can get you asylum. The agency has to analyze mixed motive cases, and you rarely see this stuff in the Fifth Circuit. I mean, here's this quote from the Fifth, quote, "When as here a religious individual refuses to assist the gang because of his beliefs, the BIA and the IJ should consider that as substantial and critical evidence supporting the claim," end quote. So like, nobody wants to give MS-13 money in El Salvador, right? If you're not MS-13, nobody wants to get extorted by these gangs. And so that's always a motive. Let's be
Mhm.
honest with ourselves, right?
Yeah.
But if you're also doing it for a protected ground, like a particular social group, like a religion here, you've got a potential claim. There's a Fifth Circuit putting it in black and white. In addition to this huge jurisdiction decision, Argueta Hernandez v. Garland, published on December 5th, 2023, is an important decision, especially if you're in the fifth. And of course, this is the December summary on your show, John.
Yeah. Well, interesting stuff. We'll see how that one plays out. That side of immigration law is always like when you tell me this stuff, I'm like, oh my God, like I thought USCIS stuff was crazy. This is
Crazy.
next level.
It's crazy. I mean, that's a huge issue baked inside of another huge issue, baked inside of another huge issue. You know what I mean? It's just wild, right? What is past persecution baked into mixed motive nexus, baked into jurisdiction and time deadlines? It's wild. So
So,
then I always like to do three on your show. So I'll be quick with United States v. Chavez, which again, December 7th case out of the Second Circuit. And this really just follows United States v. Minter. I just want to talk about it wherever I can, because as I read it, after Minter and now certainly United States v. Chavez, a New York cocaine conviction is not a controlled substance offense for immigration. And New York's a big state with a lot of immigrants in New York City. It's a big deal, even though these are all happening in the sentence enhancement context. And United States v. Chavez is just applying the Minter logic to maybe a different statute or an expanded statute, and it's actually saying that actually it's not even only about New York cocaine. It's about New York's definition of a narcotic. So New York will allege that someone violated a narcotic law, and within the definition of narcotic is cocaine. There are other things, but it's not divisible as to the thing. And one of those things, cocaine, is broader than the federal definition because it has overbroad isomers. This whole isomer argument that I'm always talking about, that people have been talking about for years, that the Ninth Circuit adopted for like a month, a long time ago, and then reversed itself. But now all of the other circuits, or a lot of the other circuits, are starting to get on board. The Second Circuit being one of them. And it's having huge implications, particularly in the cocaine and methamphetamine contexts, or any statute that is relying on cocaine or meth. So big deal stuff.
I mean, all these cases all together, it means like the whole system could like implode when they try to fix something.
No, I mean, look, there's enough crimes, there's enough criminal activity, but yeah, I mean, I
It's
don't
gonna add
think you
up to a
can.
lot of deportations or orders like that are caused by this interpretations or old interpretations. So
Yeah, I mean, in the marijuana context, there's case law that says as society's views of marijuana change, so too does the CIMT definition, and you've got the FDA making marijuana not a Category 1 offense. This is not the same. This is cocaine. I understand, but like, the drugs in America, what
yeah, it's
it's a
heavily
pendulum.
politicized. Yeah,
And this is but this is just a categorical approach game, and it's all happening not in the immigration context. Well, most of it is not happening in the immigration context, but that same analysis and that same controlled substance definition applies in the context that's happening. Like Mr. Cherez, like he got like 10 years off his criminal sentence, something big like that of an otherwise,
yeah,
20-year sentence.
yeah,
But big stuff happening, and in every circuit. Well, even the fifth, but certainly in every circuit except the fifth, non respondents counsel should be, making these arguments that cocaine is overbroad and preserving them. And even the Fifth Circuit, but the Fifth Circuit requires that you find a case, talk to the Padilla attorneys like
yeah.
Jordan Pollock in outside of Dallas, because apparently they have found a case, is my understanding. Don't tell anybody, John. But yeah, I mean, preserve the arguments everywhere. It's
Yeah,
wild stuff, and especially if you've got like an LPR who made some mistakes like 20 years ago, right? Like totally different person
yeah.
now. Is it just to deport that person because of a cocaine offense 20 years ago? It might be what the law requires, but is it just? And so I feel less bad about this categorical approach game in such circumstances.
Hmm.
That's just me on a pedestal.
So speaking of you on the pedestal, what's the plans for 2024, man? What vision you got
But
for this
speaking
year?
of me, what are they gonna make a statue of me? Is that what you're implying?
Maybe, I don't know. You're our idol. Everyone learns a lot from you. You have a very popular podcast.
Oh,
Which direction are you taking practice and direction are you taking the podcast?
you're too kind, John. You're too kind. I don't think anyone's gonna be making a statue of me. Um, no, I mean same old, like push ahead. They had some really good wins at the end of December for the firm, which really made me feel good. But like, I mean, whatever. I'd be lying if I said I didn't feel good about getting wins for clients, but really happy for the clients. Like some of these clients have been with us for a decade and just
Yeah.
hanging over their head and like really been like, one step away from the plane back to their country to then get that green card in the mail it was a good end of December. So keep pushing ahead in 2024. Same with the podcast. The circuits have been kind to me of late with like 2 and 3 decision weeks, a lot of it. I'm sure I'm going to get an overflow of stuff soon, but roll with the punches.
Good stuff. Yeah, I mean, there's so much to do with your practice and these extracurricular activities.
Yeah.
Hopefully, my plan is to get more professionalized on Toolbox. Every year I sell that, but then my law firm takes up so much time, and trying to
Yeah.
develop the business takes so much time. But it's always fun. The topic is good, so it's endless amount of content and things you could do with this. What we're talking about.
Yeah. I mean, what are your plans? More concrete plans.
Well, the law firm, I built it out last year. Last year I was planning, I'm gonna have a podcast episode about this, but like I was planning to just do a lot more videos and have a team do it. But just between household responsibilities, my third kid, not sleeping, all that kind of stuff, I
Oh
like
my goodness.
couldn't do any videos. I was like essentially last 3 months last year, I didn't do any videos. Luckily, the good thing about social media is like it's an investment. So if you have videos and even if you're not doing new ones, they're still alive and producing. So that's really was amazing. I've seen that happen. But really, I'm just thinking like all the stuff I couldn't do because I was a bottleneck, firing myself in that role and constantly giving it to other people to do. And so I'm learning how
Yeah.
to be a leader and have a team and all that kind of stuff. I never intended for that to happen in life because I just didn't like the responsibility. But now I had to step in it and I want to step in it. It's just learning how to, manage a team and have systems and write up standard operating procedures. So this whole year is going to be just a lot of operation stuff, so that I could keep detaching myself. That'll open up the time for me to start doing the magazine again. It's been a year since I published that. I
Really?
have like 8 podcasts recorded that I haven't put out yet. I got to put out. So it's just like I got really badly sick, and everyone got this, right? This crazy ass flu. It took like
Yeah.
10 days to get better. It was like insane. That knocked me out. I was hoping to get a lot of work at the end of December, but that one just knocked me out. I couldn't even like get out of bed. But that's the thing. Yeah, professionalizing the firm so it grows, and then using the extra time to professionalize the toolbox. I really want some good team members on there to help me next level it. That's been a problem, but like to get the people and all that kind of stuff. But yeah, it's all having teams do stuff. It's really good. Like right now, I started where um, before I'd write my own newsletter, but I'm like, okay, I have a team member. I'll talk with them and I'll say, just transcribe what I said, put a newsletter. And so like I published a newsletter in like a day now after doing it because someone's helping me as opposed to like putting it out for 4 months because I don't know, I don't feel like sitting down to write it. I was like, oh, I could just audio tell it to
Yeah.
someone else and they could do it. And that I was like, oh, okay, these are systems. Like I should have done this a long time ago.
That's awesome. Yeah, no growth without delegation and systems. That's fantastic.
Yeah, and the lack of ability to work last year forced me to just psychologically give in and stop wanting to do everything myself, which is the constant problem probably a lot of people have. It's just like I don't have to do everything. There's competent people around me that do a great job, and
Yeah.
a lot of times I see that they do a better job than I do. So it's like, oh wow, I could have had them do this nicer, more time and more thoughtful kind of thing, and I was holding myself. So a lot of it is that just grow a company, become a real businessman, all that kind of stuff.
I mean, I can't believe it's been a year since you published the magazine. You should know, I have a link to my article in your magazine in my show notes on the pod. So I'm promoting you every
Thanks so
week.
much. I appreciate that. I really appreciate it. All right, so stick around for a couple minutes, but thanks for coming on the show again. If you want to reach out to you, obviously, it's what's the email and social media and your podcast, obviously, Immigration Review.
That's right. Gregg, Kgregg at kktplaw.com. Immigration Reviews my pod. We're doing it together, John. You and yours, me and mine. And before I go though, I won't get into it, but check out H.N. Ferreira by the BIA as well last month if you're non-citizens bar. It's kind of been under the radar, but it's got some good language on the broader authority, as I read it, of an immigration judge to terminate removal proceedings, not necessarily tethered to what DHS wants. At least that's one reading of the decision, which, it comes in handy, especially after Jeff Sessions was really trying to rein that in. So check H.N. Ferreira out as well. Came out of San Diego, too.
Yeah, I saw San Diego part. We got local, okay. Jan Bahar.
Jan
Okay.
Behar, yeah.
Yeah.
And look, I always try to be safe. I always try to be respectful and safe and all of that when summarizing a case, because you never. First of all, it's just courtesy and it's the bar. But second of all,
Yeah.
you never know if you're gonna appear before that judge, right? But when it's a San Diego case, I'm like on high alert.
Yeah, it's interesting. Like it says, given the significance of a respondent's interest in securing a review of a denial of a petition to remove conditions, I-751, the immigration judge should ordinarily review the denial of foreign citizenship upon request of respondent. You think they would have done that automatically, but you got to request it.
Right, right. Well,
Depends on the judge, I guess.
it was only because DHS was trying to terminate proceedings, and that is, I mean, that is what it is. And as far as the narrow thing, like it's essentially the BIA saying you shouldn't terminate an I-751 review. But that was more interesting to me is that the BIA is saying IJs have authority to control the substantial authority to control their docket and to independently adjudicate cases, and that the only limit on termination is that termination must be consistent with the law. So, we're going from Jeff Sessions saying IJs can't do like anything unless I say they can, or the regulation expressly says so, to IJs have this substantial authority to control their docket, and the only limit is the law. So the I-751 thing is interesting. I don't think it's going to come up very often, but the greater importance on termination authority was interesting to me.
Mm-hmm. Yeah, I'm gonna read it. I'm gonna read it. I-751s, you gotta be on top of every aspect of it too, because it's just no new so nuance. But thanks so much. I appreciate it. Bring this to attention. We'll see you back in next month. And again, everyone catch this great info, much more detail at Immigration Review, found wherever podcasts are available.